Good morning, and welcome back to our second day of our conference. And delighted to kick it off with a great series of panels today, with our first on intellectual property and the administrative state. And so, without much further ado, my excellent colleague Ross Davies will take it from here. So, Ross.
Thank you, Adam. I'm going to keep it short because we only have about 90 minutes to hear, obviously, not everything these folks have to say about intellectual property and real IP reform. But we want to cover as much as we can. So just very briefly, we have, through the magic of the internet, Professor Gary Lawson from Boston University, who is apparently literally from Boston University today. Thank you, Gary, for joining us. We have Artie Rye, all the way from Duke, and really here. Mike Clipper, all the way from, all the way from here, yes. And Professor Sandra A. Stars as well. Each of them is expert and experienced in a sufficiently wide range of topics involving the Constitution, the administrative state, the legislative process, and in some instances even intellectual property, that there is just not enough time to go through it all, so you'll just have to take it on faith or on personal knowledge that they are well qualified as well prepared to talk with you today. And the way we're going to do this is Professor Lawson is going to speak first for 10 or 15 minutes, followed by comments from Professor Rye. Then Professor A. Stars will do the same with comments from Mike. And then we will open things up for questions. So no need to raise your hand while they're talking. You will get your chance at about 10 a.m. To start grilling them yourselves.
So good morning. I'm Sandra A. Stars. I'm a professor here at George Mason University, Scalia Law School. And I am here to talk to you about Copyright Office, structure and function, not just here in the United States, but internationally. And you might be asking yourself, why tiptoeing towards greatness? And wondering, has Sandra suddenly become a secret, closeted Trump supporter? And before you start worrying that that's the case, and that I'm going to start showing up wearing Make America Great Again t-shirts at the next CPIP event, I will remind you that before there was Make America Great Again as a slogan, there was Make the Copyright Act Great Again as a slogan, when then Register Maria Palante called on Congress to enact the next great Copyright Act. And so after many years of hearings, 100 witnesses, we are now just tiptoeing towards greatness. So instead of tiptoeing towards greatness, I would like to suggest to you a bolder proposal, that we create a new cabinet-level position responsible for culture, that we combine all of the federal arts programs and the U.S. Copyright Office in this new agency, that we transfer registration and recordation functions to the U.S. Patent and Trademark Office, that we remove the U.S. Patent and Trademark Office from the Commerce Department and elevate that also to a cabinet-level agency for innovation, and appoint a commissioner of copyrights to oversee the copyright registration and recordation functions within the USPTO. And I think that will bring us a number of new benefits. First, both the new Agency for Innovation and the new agency responsible for culture will have cabinet-level access and accountability to the stakeholders and the public. By combining the various small arts agencies that are often under threat of elimination, we will potentially gain the support of both Republicans and Democrats for this suggestion. The Republicans, as you may have heard, have already proposed removing the USPTO from the Commerce Department, so there may already be some support for at least parts of this proposal within Congress. I think by unifying the responsibility for culture funding and the regulatory and policy responsibility for copyright functions within one agency will ensure that there's sensitivity to the arts and culture and creative community in the cabinet official selected to run this new agency. And similarly, the newly created and elevated Agency for Innovation will have similar high-level, appropriately targeted innovation policy expertise. And I think these changes will reflect the importance of copyright and innovation industries to the economy. All of this also would benefit from some unification within the USPTO of the commercial functions that are so important to copyright as well as patent and trademark, because by transferring the recordation and registration functions to what is now the USPTO, we could allow for some reduction in staff and systems costs, which are currently both underfunded and not properly functioning in the Copyright Office. And by combining all of these commercial IP functions in one agency, I think we would maximize on the expertise that we could expect from that agency. So what's the current status? After all of these hearings and discussion that we've not had much movement on the legislative front. We have one bill, the Register of Copyright Selection and Accountability Act, which passed the House in April, a companion bill that's pending in the Senate, but neither of these bills really make any bold moves. They would only make the Register of Copyrights a presidential appointee subject to Senate confirmation, but make no other changes in structure or function of the U.S. Copyright Office. And then along with this, we have a recently introduced, on October 4th, Copyright Alternative and Small Claims Enforcement Act, which is a very laudable an important bill, but would also benefit from larger and more bold changes in the Copyright Office structure and function. Why do I suggest making these changes? The students of the Arts and Entertainment Clinic, which I run here at George Mason, last year conducted a review of over 208 countries' copyright registration, recordation, and administrative regimes around the world. And what we learned from that review is that the United States attracts more registrations than any other country in the world, but it does not elevate its Copyright Office and recognize the stature and the importance of the copyright industry as significantly as other countries around the world do. I've shared with you some of the statistics that the Copyright Office shares with the public on its website, and I invite you to see for yourselves whether you can find any other country around the world that is so creative and so productive in its cultural and information sectors. So just as a reminder, here is the role and functions of the U.S. Copyright Office and the Register of Copyrights. I'm not going to go through all of these functions for you, but I'll just remind you and make the main point that despite the important role that the Register plays in advising Congress and federal departments and the judiciary on matters of copyright, and the important involvement that the Register has in international matters of copyright, the office has no independent regulatory or adjudicatory function, and the Register is appointed and serves under the librarian's supervision. So how do we compare internationally? I mentioned that my students surveyed the copyright laws and regulations of 208 countries in 9 regions worldwide last year. They determined both the name and who had oversight over the office, whether the offices performed registration and recordation functions, whether those functions were mandatory or voluntary, what benefits accrued to entities who recorded or registered works, what fees were associated with this activity, what statistics existed in each country about registering or recording works, whether a deposit function was managed by the Copyright Office in those countries, and what other powers those offices exercised, such as rulemaking or adjudicatory or enforcement powers. And what we learned was that there are various worldwide trends, but no one singular approach around the world. Structurally, copyright offices are often situated within a relevant ministry or department, such as a cultural ministry, or they're grouped with industrial properties in a freestanding intellectual property office. For example, it's a clear trend in the European Union to have a copyright office housed in the Ministry of Culture or in an IP office. Similar regional trends exist also in the Middle East and in Africa. Other places where you might commonly find the Copyright Office include a Department of Commerce or the AG's office. I'll share with you some slides, and I actually believe that the author of these slides is in the audience. But this is just a quick snapshot of what the EU does. All of the EU countries have some office dealing with copyright issues, unsurprisingly. 12 of those countries house the office in their Ministry of Culture. 6 of them have one in the Ministry of Justice, and 5 of them have their office in a unified IP office. Those 5 are the UK, Spain, Slovenia, Hungary, and Croatia. Romania is the only country in the EU which has an independent copyright office, and that's funded through the Ministry of Culture, similar to what I would propose we consider here. In terms of registration and recordation, there are 13 countries with copyright registration regimes. Some of them are privately run, but most are government run. But recordation is quite uncommon, and we identified that only in 3 countries in Europe. But deposit is a very important part of the regime around Europe, and the requirement is frequently a mandatory requirement. The reasoning for this is for cultural preservation purposes and to build the collections of the national libraries. This is also consistent with the history of the United States in terms of how we've built our national library. The United States has experimented with a variety of ways to organize the copyright function of registration and deposit since the first Copyright Act was passed in 1790. At first, the registration function was decentralized and it was handled by the federal district courts. But later, it was given over to the Library of Congress and centralized within the Library of Congress. This happened after a variety of other experiments with how to structure the recordation and the deposit functions. It's not a surprise that deposit has played such an important role, at least in the early years of the evolution of the Copyright Office in our system, given that our copyright system is premised on the English Statute of Anne, which included a provision for sending deposits of registered works to various British libraries. There have been various recent attempts to, or relatively recent attempts, I should say, to restructure the Copyright Office. None of them passed, and all of them shared a few common elements. They were motivated in large measure by technological changes and fears that Congress could not legislate quickly or expertly enough in the area of copyright and technology. They were frequently undone because of concerns that one entity or another would exert too much influence over the Copyright Office, and there were often some tensions and worries raised over the library continuing to maintain sufficient control and flow of copyrighted works into its collections. All of these elements also exist in the conversations currently happening around the Copyright Office structure and function in the current legislative discussions here. However, I think by moving more boldly to create two new and more independent and more elevated and parallel IP bodies, we may actually be able to balance and sidestep some of the concerns that have been expressed in the past. Moreover, I think by consolidating the registration and recordation functions in an agency where other such business facilitating transactions occur, perhaps we can gain some economies of scale. So I mentioned the small claims bill, which is also pending, and it's worth saying a couple of words about how small claims fit into this whole issue. There's a good reason to restructure the Copyright Office in particular, and I'll wrap up in just 1 minute, more substantially and symmetrically, rather than to merely elevate the registrar's position to a presidential appointed post, because the Copyright Office structure is anomalous both domestically and internationally. Modernizing the Copyright Office as part of a larger cultural agency within the executive would insulate it against various constitutional challenges that have been raised about this small claims proposal. I'm sure that Mike will be happy to tell us more about both those challenges and why we should not be concerned about them. But modernizing and upgrading the status of the Copyright Office would also harmonize our approach with dominant trends internationally. I won't say anything specific about the internet courts which exist around the world, other than to note for you that there are at least 3 programs addressing small claims entirely online that have met with a good deal of success, in particular in China, the Hangzhou Court of the Internet, and that is also good evidence for rebutting and giving us some peace of mind that some of the concerns that have been raised about the small claims proposal either being not popular enough with people with claims or too popular, on the other hand, are also worries that we might set aside. So thank you very much. To share further thoughts after the event, please feel free to contact me at my Mason email. Thanks very much.
Thank you, Sandra. And now, Mike.
Can you all hear me? Yes? Okay, I will sit here then. Thank you, CPIP, for inviting me, and more importantly, for the important and increasingly critical role you play in the IP field. It's a pleasure to be here and share with you some of my thoughts on Sandra's paper and related issues. My usual disclaimer, the views I will state today may be mine, some will, some won't maybe, but they are not those of any of my clients. And also in matter of disclosure, I am involved representing clients in the small claims, supporting small claims legislation. If I seem a little weary this morning, it's because I stayed up way too late last night and I'm suffering from a malady that seems to occur all too frequently in October, spending the entire season with some of my colleagues in the audience, watching and then talking around the water cooler at work about the Nationals and their unfortunate tendency in October to break our hearts. So if I'm a little slow and my voice is a little rough, please don't hold that against me. I think the one initial comment I want to make when we talk about any of these modernization changes and Sandra's proposal and others is we're talking about a political process, which makes it a very difficult one and sometimes hard for people to understand outside of Washington. Copyright, which I've been doing for over 40 years from the policy perspective, is a little different than your typical legislative situation. Party rancor and partisanship really doesn't define the problems we face. There are others. In fact, virtually every copyright issue I, Sandra, Troy, others in the audience have worked on, Keith, over the years, have been bipartisan in nature. The small claims bill, which was just introduced, was introduced by a Democrat and Republican as the primary sponsors, and then a mix of Democrats and Republicans below them. That's not the issue. I think the issue in part is a fear that people have when you start talking about a comprehensive copyright bill, which is what's happened after the speech by former Register Palante and as Sandra indicated, 4 years of hearings, traveling shows by the committee to places like Nashville and Los Angeles. I think what we see is that there's a uncertainty in the various IP communities, users, owners, tech, et cetera, of where this is going to go. And there's always the fear that a bill, no matter how small and tailored, could become a Christmas tree for other things. And you always worry about if you are getting something, what it might cost you. So I think that makes everybody a little nervous in this world about it. And I think that just, so everything we're going to say today and everything that Sandra's alluded to, I think has to be viewed very much through from a political vantage point. Mr. Goodlatte did hold 20 hearings, 100 witnesses. You name the copyright issue, it was up there. Fair use, DMCA, music licensing, et cetera. Now the question is, what happens next? His term as chairman, to be a little political, expires under the rules of the House at the end of this Congress, which means next year. Having spent all that time and effort, I'm sure, as I would if I was still working there, and speaking for my member, my senator, I would want to make sure I had a decent legacy after that investment of time and effort. And now it's crunch time. What is going to happen, and where are we going? Great uncertainty hovers over that process at the moment. And I don't know how this will shake out. No one does, really. Sandra's suggestions are added to a list of others that have been put on the table regarding how to restructure the office and deal with modernization of the office and other related issues. Some have suggested an independent freestanding agency. Others say, let's leave the office in the library, but make the Register a presidential appointee and give the office the autonomy it needs, particularly from a fiscal and technology standpoint, to move forward and do better than it has in the 21st century. Others have suggested, as we heard, moving it to the Commerce Department. Add Sandra's suggestions to that growing list. I think your comments are very provocative, but as you yourself acknowledge in your paper, they are controversial and will not be resolved in a short term. It's a big piece for Congress to chew on, and I think there's some concern there. I agree with Sandra, and we support making the Register a presidential appointee. We think that is an important step. Unfortunately, that bill is now stuck in the Senate, and its future is unclear. But I also agree with Sandra that that is really, when you look at it, a small step, and more needs to be done. I agree with Sandra that the legislation is critical. It is critical legislation be enacted to delegate to the office the authority it needs to manage its own affairs. And I think it's helpful to look at what other countries have done, in thinking about that. But I will tell you, and there are others in the audience that lived through this, Congress and judiciary committees have not always been receptive to analogies from overseas. So I'm not sure how much weight that will carry, with all due respect. I worry about that. On one level, your idea of removing the administrative responsibilities from the Copyright Office and placing them in PTO is very intriguing. And it really parrots what's happened over the years since Mr. Solberg started the office. And that is that there's been this informal, de facto, but effective dichotomy between the librarian and the office, where the librarian worries about administrative matters for the most part, but does not really engage in policy ones. That started, as you said, with the 1909 Act, and was certainly clear when I became involved at the tail end of the 1976 Copyright Revision Act, and going forward. So I think the idea of ensuring that that kind of role continues is absolutely essential, and whatever Congress were to do in this area, it's critical that they maintain that role. I mean, you cited part of the statute. The other part, 701B, as some of you know in the audience, was added in 1998 as Title IV of the DMCA. And that set forth the statutory responsibilities of the office, starting with advising Congress on domestic and international issues, conducting studies, et cetera. Whatever is done in this area, whatever is changed, it is absolutely critical, in my view, that that role of the office not merely be maintained, but be strengthened. So I think that, I agree with you on that. Whether it's doable, of course, is a very different question. I also worry, and I think we would have to pursue in detail, and I'm intrigued again by some of your comments, on what would be the economics of this change. I think some people would suggest that the idea of removing the fee-generating role of the office would raise questions about its funding and how it would continue, and I think that's something we have to look at very carefully. But I don't know how much time I have. Ultimately, I agree with you that rather than merely elevate the register, more has to be done. And I think that's where we are. Maybe that bill will shake loose, maybe it won't. But Mr. Goodlatte and Mr. Conyers, about 10 months ago, announced a plan, and they may be revising it, to have a bill which dealt with copyright modernization and the register and related issues. But they also talked about something I'm deeply involved in, and that's the small claims legislation that you alluded to. This has been about a 10-year process since this really began. The key moments, just to summarize, were in 2011 when then Chairman Lamar Smith, a Republican from Texas, asked the Copyright Office to conduct a study. A few years later, 2 years later, and 3 NOIs later, they produced a report. It's a very interesting process because it wasn't, even though people commented on all sides, there wasn't, as you see in many of these reports, a very clear split between the pros and cons. When you look at the negatives, and I think they've been addressed in the legislation, the 3 issues typically came up. It should not be mandatory, both for policy and constitutional reasons. You should be able to opt out. Injunctions should not be included because there was concern in the copyright community that a movie or book would be pulled, if this court had entered an injunction. And third, and an interesting one, which I think is responded to well in the bill, is that was a concern from a small number of folks that we have to think not just of the small creator, but of the respondents, defendants in these proceedings. I think, the reason I say I think that that was done well is that the system that is now in H.R. 3945, which will supposedly, I am told, be online today and available in text, does things that I think are very important. But very quickly, how much time do I have? What, 4 minutes? Okay. Very quickly, what I want to mention are the following. This is a court whose real beneficiaries are the creative artists, small businesses and individual creators. That's who my clients are, and that's who I think are really the ones who need this. This is aimed at curing a historical inequity within the copyright system, where all too often small creators are infringed, increasingly in the digital world. You see their works infringed, but they are priced out of federal court. We don't, while there's a cap of $30,000 on claims in this tribunal, I think it is expected that those claims will come in at a lower amount typically. Our folks talk about $1,000 to $5,000 to $7,000 being a more typical. I mean, others will deal with that. The reason I mention that I think it deals with the defendant issue is that there are multiple provisions in the bill which I think are incentives, and the question is, will they sufficiently entice them? But from the defendant's perspective, they don't have the injunctions. They have caps on the amount of the damages, and they can, for example, raise any equitable or otherwise defense available. And that was a big issue during the hearing during the Copyright Office process, because they were talking about the idea of fair use being available. Attorneys are optional. There is no fee shifting except in bad faith cases. There are a variety of provisions on bad faith. And in the interest of Sandra, and what we've been talking about for a long time, there's a very intriguing provision as someone who came out of the clinical world of law schools. There's a provision that allows law students under the supervision to go forward and to represent parties, either side, on a pro bono basis. And that provision, I will tell you, has generated interest not here, but just at George Mason, but other schools I've been talking to around the country. I will move on and not go into more details. I'll be happy to answer questions on it. I think a couple of things that you mentioned are very critical. There is a concern that the incentives be sufficient, so we don't give a party and nobody comes. I think that's very clear. On the opposite end, and this is true, I've heard this a lot, there's a concern that there be an adjudications in such a way that they can manage their caseload. So you don't want to be overloaded, and you also want to move in a fairly speedy adjudication process. Are the incentives adequate? Well, we can talk about that. Would the board be able to manage its caseload? I don't know. Will the system encourage settlements? Critical issue, how will it be funded? Even though it is estimated that funding this for a year would be a very modest amount in DC terms, will there be the interest in not merely authorizing but appropriating, even if it's just a couple of $1 million a year? Will the fees be reasonable? How expensive is it really going to be for the small creator and the individual small business? There are also, and time doesn't permit, I suspect, to go into the constitutional questions you raised. Anyone who's interested in that can get a good feel for those issues by going to the Copyright Office report, which goes through them in detail, including the Seventh Amendment, due process, Article 3 questions. And I will tell you that ultimately, just to sum up, okay, I'm out of time. Just to sum up, I think that bill is very carefully crafted. I think that there is always room for improvement. One thing that I will tell you is that bills always change throughout the legislative process, and it's not going to, nothing looks like it started. In fact, I worked on one bill that I started supporting and wound up being told, because when I opposed it, someone said, you supported it for so long, it's like calling your baby ugly. And I said, no, it's just that it went the wrong way. So there are no guarantees here, and I will say that Sandra's contribution will be provocative, should be on the table, in our discussions, but none of us would be brave enough to make any kind of prediction. Thank you.
Thank you, Mike. Well, while we're getting everything arranged up here, we might as well take this time for a question or two. Does anyone have anything for Sandra or Mike? Everything was clear and complete. We now know what's happening next.
Wait for the mic, please.
Well, I think I have a booming enough voice. Sandra, you proposed making an Office of Innovation at the cabinet level. Have you considered, though, what would actually happen if you try to do that? The real innovators within the government aren't just copyright, patents, and trademark. The real innovators are our institutes. For example, NIST is overlooked constantly as a source of innovation. But if you represent an industrial group that relies on, for example, ASTM standards, excuse me, when you go to those meetings, the 1,000-pound gorilla in the room are the scientists from NIST. People at NIH carry tremendous weight, and their actions, or FDN, you really can't tear out those functions from the institutes. And DARPA, well, it funds and is behind a tremendous amount of research and innovation. I don't know how you manage to do that without tearing apart very effective agencies.
So just in case people in the back didn't hear the question, in short form, the question is with regard to the innovation agency that I propose, how should that be set up without tearing apart the very important agencies like NIST and NIH and so forth, where very important innovation functions also take place. And I will confess that I am primarily a copyright lawyer, and my attention was primarily to the structure and function of the copyright proposal that I was making, but it seemed important to me to also note that it would be unbalanced, and I think it would be politically improper to suggest elevating the Copyright Office structure and function either to an independent agency or to a cabinet-level agency without similarly balancing things on the patent side. And so that was the main point that I wanted to make. In terms of the precise, structure and function of the innovation agency, I take your point, and I think there may be some parallels to what I suggest on the copyright side, where I'm suggesting taking the functions of some of the federal arts agencies and grouping those with the copyright policy functions. So there may be a possibility of taking, say, NIST and grouping that with the USPTO functions in this new innovation agency.
Thank you, Sandra. Mike, do you have anything you want to add to that, or?
No, but I think the only thing I would say, in the past, there have been efforts. 20 years ago, Senator Hatch had a bill to create a new entity which would have dealt with patents, trademark, and copyright under the auspices of a single presidential appointee, if I have that right, Troy. And so, I mean, Congress is cognizant that when you push button A, you may have to deal with button B at the same time.
Yeah,
But,
I mean, and this parallel problem exists also, of course, on the copyright side. There are plenty of other agencies that have various copyright functions throughout the government, and we can't necessarily pick all of those out and, put them in one place. And I fully expect that other executive agencies would still have some role to play in the copyright space.
So this is not my,
I hate to interrupt,
Oh,
but I
okay.
believe we have a window of opportunity to hear from Professor Lawson.
okay, all
And
right.
so let's go for it.
Oh, amazing.
I hope so. Can you hear this? All right, well, I apologize for the previous technical defect. I assure you, what I was saying before that you couldn't hear was so eloquent and thoughtful that I don't think I will ever be able to recreate. Gone. But I'll do the best that I can to try to equal it. I want to start by going back to the introduction by Ross Davies, who said that everybody on this panel was exceptionally qualified. That is true with one large exception. That would be me. I know nothing about patents. I know nothing about intellectual property generally. I'm not even a constitutional law person. I am a constitutionalist, which is quite different. I'm interested in what the Constitution of 1788 actually says, not in what politically appointed lawyers and their 24-year-old law clerks have to say about it. Now, most people are much more interested in what the politically appointed lawyers and the 24-year-old law clerks have to say. That's just not my thing. I do what Hugo Black used to do. I take the Constitution in one hand, I take a statute like the AIA in the other hand, and I put them together and I see how they match. Now, normally when you do that kind of exercise with a random federal statute, it's wildly unconstitutional, but for reasons that don't necessarily apply in the patent context. Usually, you're dealing with problems of enumerated powers, subdelegation of legislative authority, or both. With the patent statutes, those aren't the problems. There actually is an enumerated power. Who knew? The patent statutes are not always crisp and clean, but they tend not to say things like grant patents for the public interest, convenience, or necessity. So the usual constitutional defects with federal statutes don't leap out when you look at something like the AIA. But certain things did leap out at me when, having no background in the subject, I did look at the AIA. And it wasn't the what, it wasn't the how, it's the who, right? The problems with the AIA are not what it's doing or how it's doing it, but who it has doing it. And there are two dimensions to that problem, and let me briefly explain each. What the AIA is about is the cancellation of patents, and that's a perfectly fine thing to do. Patents create legal boundaries, and there are people who sometimes want to try to cross what those boundaries are. So it's very important to know which of those boundaries are valid or not. And at any given moment in time, there's going to be a universe of patents, and some non-trivial subset of that universe is going to be objectively invalid. It just is. The system is too complicated, human beings too frail, for there not to be an enormous universe of invalid patents at any given moment, right? The question is, who is it under the Constitution that is supposed to identify that invalid subset? And it's very tempting to think that because executive agents are the ones who issue the patents in the first place, that they must also be the ones who can identify the invalid ones. That is the fundamental constitutional defect with the AIA. It's not executive agents who are supposed to make those determinations, it's judicial agents. Here is why. The Constitution of 1788 does not create and empower a national government. It doesn't. It creates and empowers a certain network of institutions that you can collectively refer to as the national government, but all of the powers are granted to particular institutional actors. That's the familiar, some legislative powers over here, executive powers here, judicial powers here. Now, if you draw Venn diagrams representing those powers, there's going to be some areas of overlap, some things that any one of those empowered institutions can do. But there are also going to be individual blank spaces, things that are only within one of the circles in the Venn diagram. There are some things only legislative actors can do, some things only executive actors can do, and some things only judicial actors can do. Now, Both today and in 1788, those lines were often very blurry, but some of them are actually pretty clear, and the AIA manages to cross one of the clear ones. Once a patent issues, it is property. It's what people in 1788 would have called a vested right. Now, in a metaphysical or existential sense, some of those patents won't, quotation marks, really be property because they will be legally invalid. But from the standpoint of the legal system, they are property until they are properly declared not so. Just like land titles, there may be some land titles that are objectively, if you had all knowledge in the universe, invalid, but the legal system treats them as property until that determination is made. Only courts can undo vested property rights. Well, that's not entirely true. Legislatures can do it through the exercise of eminent domain, where they acknowledge that you have property, and they acknowledge that they're taking it away from you, but they're providing just compensation. If what you want to do is take a vested property right and say, no, it really isn't, that is the sort of thing that only a court can do. Why? Because you can only deprive someone of life, liberty, or property with due process of law. And due process of law, circa the late 18th century, just is judicial process. Modern law has that totally wrong. Due process of law is not about procedure. It's about substance. It's the substance of who decides. This has been true from the 13th century onwards, from Magna Carta to the present. It's all about who gets to make certain kinds of decisions. The 19th century courts understood this perfectly well. They had to deal with invalid land patents, and they made it very clear that only a court could declare a once issued land patent invalid. That's just what due process of law means. It means things done by judges. It does not mean things done by executive agents that use procedures that sort of, kind of, sometimes look a little bit like what judges do. Right? Mimicking judicial-like procedures does not turn executive action into due process of law. It just doesn't. It can't. That's not what the concept is all about. As Marvin Gaye and Tammy Terrell put it so eloquently, ain't nothing like the real thing, baby. And you can't duplicate it within an executive structure. So it's perfectly fine to have a legal system set up a mechanism for canceling patents. They just picked the wrong people to do it. The second problem with the AIA is one that is more easily fixable by statute if anyone wants to take it seriously, but it's a problem nonetheless. And that is, even if you've got the right people doing it, you still have the wrong people doing it. That is, even if executive agents can in fact cancel patents, the AIA has picked the wrong executive agents. And there are three features of the statute that generate this problem. Number one, the PTAB members, with one exception, the director of the PTO, are appointed in a fashion that is, thanks to Professor Duffy, appropriate for inferior officers of the United States. They're appointed by a head of a department, the Secretary of Commerce. One is appointed by the president with the advice and consent of the Senate, but only one. Second feature, all decisions of the PTAB must be made by panels of at least 3 members. The PTAB cannot act without at least 3 people involved. Third, once the PTAB issues a decision, there is no higher executive authority other than, in a strong form, unitary executive, the president, who can review any of their decisions. The only entities that can review PTAB decisions are the PTAB itself through rehearing or the Federal Circuit Court of Appeals. Those 3 things in combination make PTAB officials principal officers of the United States. And under the Appointments Clause, principal officers of the United States must be appointed by the President with the advice and consent of the Senate. There is no other way. So every single member of the PTAB except one, the director of the PTO, cannot exercise the functions vested in them by the AIA because those are only functions that can be performed by principal officers. Why is that? Because what makes somebody a principal officer is precisely that. There is nobody other than the president within the executive that can overturn their decisions. This one not only is correct as an original matter, but also more or less kind of gets reflected in the modern case law if one is concerned about that. Edmund versus United States and Free Enterprise Fund both emphasize the hierarchical character of the executive decision-making process for determining who's a principal and who's an inferior officer. And as a matter of the original meaning of the Appointments Clause, that is absolutely crystal clear. It is all about hierarchy. Now, the only way out of that one that I can see, and maybe the patent experts here can explain that that really does work. If the PTO director personally can exercise all of the functions of the PTAB, that is, could simply take a PTAB decision and say, screw rehearing, I'm simply inserting my own view as the correct one and that's it, then the statute is probably fine, because then you would have a principal officer exercising the functions. That seems to me a very unlikely interpretation of the statute. Perhaps a very strong dose of an avoidance canon could lead someone to construe a statute that way. But absent that kind of statutory manipulation, I think the PTAB is unconstitutional as currently constructed, at least with respect to the functions that it's granted by the AIA. So if John Duffy can have something named after him, the Duffy defect, I would like to call this problem the Lawson lacuna, and see if anyone can figure out a way out of that. All right, so with that, I'd love to hear what Professor Rai and anyone else has to say about why this is all wet. Thank you very much.
Thank you very much, Gary. Although there are many things, as Mike pointed out, that are unpredictable about the processes we're talking about here, the possibility that Professor Rai has something to say, I think is pretty certain. And so I believe now is the time, and we're going to hope that Professor Lawson can stay online long enough to field a few questions once Professor Rai is done.
Yeah, absolutely.
Thank you very much.
Thanks, Ross, and I'll take that as a compliment. Whether it was meant that way, I'm not sure, but I will certainly embrace it fully as a compliment. First, thanks so much to Adam Mosoff for inviting me to comment on this excellent paper. I don't know if Professor Lawson can hear me, but it was truly a pleasure to read, and those of you who haven't read the paper should know that the title of the paper is Appallingly Illegal Adjudication, the AIA through a Constitutional Lens. So I love that, appallingly illegal, wow. So I want to comment on those issues, but before I do that, I do want to give Professor Lawson's paper, not surprisingly given that he is a constitutionalist, has a laser focus on the constitutionality of the PTAB, but because this panel is about improving IP administration, I do want to step back for a moment and think about the PTAB through a slightly wider lens, through the larger patent system in which the PTAB operates. And I do think that this wider lens is important not only as a policy matter, and I have to confess I'm not a constitutionalist. I do look at constitutional law, but I mostly do administrative law, and I'm also very interested in policy questions. So perhaps Professor Lawson and I come at the question a little bit differently. So if you step back and look at the system through something of a wider lens, one really interesting feature of the larger system of which the PTAB is a part is how judicial review of PTAB operates. That is, how the PTAB is reviewed by the Article III judiciary. Everyone agrees, and I don't think anyone would disagree with this point, that this review has to be based on the Administrative Procedure Act. That's what I teach in administrative law. I spent almost all my time on that point, the Administrative Procedure Act, because that's the backbone of the administrative state. As Professor Lawson knows, I expect many of you know as well, under the APA, the reviewing court is entitled to have the agency prove that it engaged in reasoned decision-making. That's a term of art, reasoned decision-making. Now contrast that with judicial review of patent grants. I've written scholarly articles arguing that this review of a patent grant should also be based under ordinary principles of administrative law on the APA. And John Duffy, whom Professor Lawson and I both respect greatly, has made that argument actually in various briefs, including to the Supreme Court. The courts, including the Supreme Court, have refused to accept that argument. Instead, they've deferred almost completely to the PTO's decision to grant, saying that anyone who challenges a patent has to show not anything under the APA, like reasoned decision-making, or the PTO didn't engage in reasoned decision-making, but rather that the PTO's grant was, quote, clearly and convincingly, quote, unquote, incorrect. In fact, the Supreme Court has said that this clear and convincing standard applies even if the challenger proves that the PTO missed relevant prior art. So there is, at least on the APA, as I teach it, no decision by the PTO to which the court could defer. So the upshot is that the courts have given themselves much more room, ironically enough, to aggressively review what the PTAB does and what administrative judges at the PTAB do in the few hundred cases they decide every year through trial-type adjudication than what the PTO routinely does in the hundreds of thousands of grants it gives each year via lower-level patent examiners. Now, one might argue that all of that is nice, functional policy stuff, but it's trumped by the formal distinction between a patent grant on the one hand and a decision to take away a patent on the other, and that is the formal distinction that Professor Lawson stresses, and that only an Article III court can take away a grant no matter how little review can be given to that grant if a challenger gives it, makes the challenge. Okay, fine, I will talk about that in a minute, but nonetheless, it's striking to me that those who are concerned about administrative usurpation of judicial power aren't a bit more concerned about the abdication by Article III courts of any review of grants in the ordinary non-PTAB context. Now, to be fair to the courts, it could be that their already strained dockets couldn't possibly sustain such searching review of the hundreds of thousands of PTO grants, particularly if the possibility of such searching review encouraged those against whom patents are asserted to bring even more invalidity challenges instead of simply licensing a questionable patent. But all of that does mean, as Professor Lawson admits, that there's going to be a very substantial number of errors that are going absolutely uncorrected by the courts. Congress recognized this problem as early as 1981. So the PTAB is an extension of stuff that's been taking place since 1981. And all applicants to the PTO for a patent since 1981 have applied knowing that there's going to be some post-grant review of some sort of their patent if it's granted. So they have applied under that provision which provides notice. So, with all that, now let's turn squarely to the Article III question, which is now, as you all know, and I suspect Professor Lawson knows as well, to some extent the oil states question at which the Supreme Court is looking. Now, Professor Lawson's article adds a very interesting due process gloss to these Article III arguments that the briefing thus far has not really engaged, I think in part because I think Professor Lawson is absolutely right. The modern law is procedural in its due process orientation. I don't teach any due process cases that are not procedural because I actually don't know what I would teach if I were to do that. So let's go back to some of the discussion, also mostly in the paper, of the Article 3 question, independent or not primarily focused on due process. I do agree, and Professor Lawson notes this in the paper, that the case law from the Supreme Court since Kroll versus Benson, which is a 1932 case about the scope of Article 3 power relative to executive power, I agree it's quite confusing. I think Professor Fallon, who is the editor of the legendary Hart and Wexler book, put it best when he said, would it be fair to say that the Supreme Court has brought little but confusion to the area since Kroll versus Benson? That was a rhetorical question, I think, to which the answer is clearly yes. That all said, and I'm happy to get further into this into the Q&A, I do think the 20th century case law from the Supreme Court is the applicable law, that is the law since Kroll versus Benson. I'm not a constitutionalist. I am just a humble lawyer. I think that's the applicable law. I believe that it is good law. And I think the better reading of this post-1932 case law means that federal statutory rights that are granted by an agency can also be corrected, at least in the first instance, by the agency, subject to vigorous APA-based review. Again, the PTAB is the only context where the agency is subject to vigorous APA-based review. Interesting. I think the analogy to vested rights and land patents is interesting, and there's an 1898 case that also makes that analogy from the Supreme Court, again, pre-1932. I would suggest that Professor Lawson also look at Caleb Nelson's article on this question where he talks about land patents quite a bit. He doesn't talk about intellectual property patents in that article, but as I recall, I haven't gone back and read that article closely in the Columbia Law Review recently, but as I recall, the land patent rights issue, exactly when they vested was not a completely settled question, so that may be worth looking at as a constitutionalist, which I am not. But if one is a constitutionalist, as Professor Lawson is, that may be worth looking at for purposes of the paper. But at the end of the day, I'm a humble lawyer. I'm not a constitutionalist. The Supreme Court has not disavowed the 20th century cases, and I consider them law. Okay. For that reason, I'm actually more interested in a lot of ways in the appointments clause question that Professor Lawson raised. I think that's a really interesting question. I too believe, and Professor Lawson and I share the mutual admiration for Professor Duffy. The Duffy defect, the identification was very clever, and of course Congress knew it too, and they fixed it as a consequence of Professor Duffy's intervention. So I agree that PTAB judges are officers. Like Professor Duffy, however, I think they're inferior officers and therefore are constitutionally appointed as the AIA is currently constituted. One simple doctrinal reason is that unlike administrative law judges, PTAB judges are administrative patent judges. They enjoy no protection from being fired. So under the Supreme Court's peekaboo precedent, I don't think they can be principal officers. In fact, that's how the Supreme Court revised the statute at issue in peekaboo to allow for the firing of the individuals on the board whom they were worried about. Now, Professor Lawson does suggest in the paper that the peekaboo court, this is a 2009 case, got it wrong. Maybe, but removability was also a factor, as I understand it, in the Edmund case that Professor Lawson cites very prominently and I think agrees with. Now, there's another argument that I've made about this specific issue, which is why I'm so excited that Professor Lawson brought it up. I made it last year in an article that Professor Benjamin and I, Stuart Benjamin and I, wrote in a 2016 issue of the Duke Law Journal, specifically dedicated to the PTO and the administrative state. Now, we made this argument in the context of Chevron deference and why arguably certain decisions of the PTAB that were reviewed by the director might get Chevron deference. But I think it also applies to the Appointments Clause. The argument is basically one that the majority of the Federal Circuit agreed with, all but 2 judges of the Federal Circuit agreed with in a 1994 case called Allapat. Basically, in the statute itself, Congress provides for the director to expand any panel with which she or he disagrees and appoint on the expanded panel her or his own lieutenants so as to render a decision with which she or he will agree. So, functionally, and I know that Professor Lawson is not a functionalist, but functionally, she or he can pick the panel if she or he doesn't agree with the PTAB's original decision. Now, Professor Lawson does say in the paper, quote, and this is a great quote, "Picking the panel is not the power to decide," unquote. I think that if you can handpick the panel, you have the power to decide. And in fact, that issue is precisely the issue that some of the litigants, or the petitioner in particular, in the Oil States case is bringing up. The petitioner is upset that the director is handpicking panels so as to achieve uniformity in PTAB decisions. Well, I would say that the director has the authority to do that. But whether or not the director has the authority to do that, she in that case, or he, clearly is doing it. So I don't see this as an appointment of that the PTAB involves appointment of principal officers. So thanks so much for a very provocative paper. I just thought it was terrific, and I had so much fun reading it. And I look forward to everyone's thoughts and questions. Thanks again. And thanks again to Adam Mosoff.
Thank you very much. Thanks to everyone on the panel who, in addition to volunteering to speak, have volunteered to now field questions, I believe. And I think we had some hands up. Why don't we start down here? Because I think this hand has been up, or at least in spirit has been up since. Yeah. Oh, so now you're piling on. Okay, so but.
For Professor Lawson.
Oh, I think we have a microphone for you right there.
Oh,
thanks.
Good. For Professor Lawson, what do you think of state zoning laws? There's usually an administrative review during the process. That's taking land, that's depriving the use of people of their land. Is that unconstitutional under your logic?
What was the first 4 words? What do I think of what?
State zoning laws.
State zoning laws. Well, since nothing that I said applies to state governments, because I'm talking only about the structure of the federal government, it's a whole different question. If you're analyzing state laws under the federal constitution rather than the state constitution, you'd have to be looking at the 14th Amendment, which is a whole different provision. So I'm not a 19th century guy, I'm an 18th century guy. I try to stay away from the 14th Amendment as much as I possibly can. But that's where you'd have to look for your answers. Perfectly good question. It's just it's a different set of constitutional provisions that would be relevant for answering it.
I have a follow-up. Sorry, I don't see the difference.
The difference is
I know it's
the Constitution's all about the federal government, and then there are a couple of odd little provisions here and there that talk about state governments.
I know we're implementing it. Let me take the question to federal.
But before we do this, let's find out if anyone else on the panel has something to say in response to this.
So I actually had a comment on Artie's comments and on the Appointments Clause issue, just to note that there is a parallel issue in the Copyright Office with regard to the copyright royalty boards, and a fairly recent case, I guess, the intercollegiate broadcasting case.
Where the DC Circuit said, we'll remove that part of the statute that says the judges can't be fired, thus making them equivalent to PTAB judges, and thereby, according to Senior Judge Williams, rendering the statute constitutional.
Exactly, yeah.
Okay, very good. So next, I think we're over here. Yep.
So, I think his question was a good one. What about the trademark trial and appeal board? Is that unconstitutional? That is a federal question for you. How do you distinguish the grant of the patent and the grant of the trademark? Or does your logic render the TTAB unconstitutional? I think that's what he's driving at.
Gary or Artie?
Yeah, that was to me, the only word I heard was trademark.
That's the word. Trademark Trial and Appeal Board.
The trademark trial and appeal board, does that have some of the same defects?
Yes.
Is that the question?
That's it.
I'd have to look at the statute. I only looked at the AIA because I was invited to this conference and figured I'd better look at the AIA in order to say anything at this conference. But, I don't do intellectual property. I don't do patents, trademarks like Professor Rai. I'm an administrative law person. So I'd have to look at the statute. It's quite possible it's going to have some of the same problems. If you've got an executive agency that's allowed to cancel trademarks, then the question would be whether trademarks have the same status as vested property rights as patents do. I'm quite convinced, based on the research I've done, that patents once issued are vested property rights. If that's also true of trademarks, then you would have the same problem there. Whether you would have the appointments clause problem with the trademark trial and appeal board, I'd have to look at the statute. That's just not, I didn't look at that.
There you go. Constitution in one hand, statute in the other.
Exactly.
Yeah, okay.
So can I just say something about the
yeah, sorry.
TTAB? So I think the TTAB, interestingly enough, might be even more problematic in some respects, not necessarily under Professor Lawson's logic, but under, if one is to take the 20th century case law seriously, because trademarks have a common law origin that patents have never had. And so, and yet, Justice Thomas declared patents to be quasi-private, only quasi-private rights in a recent decision on this question, B&B Hargis. So, I don't see how the Supreme Court, under 20th century case law, can declare the PTAB unconstitutional.
Can I say one thing about Professor Rai's comments, by the way, that are completely off the topic from anything that I said in my talk? And yes, speaking as a fellow administrative law person, Professor Rai is absolutely 100% right about the relationship between the APA and the Patent Office. As she so eloquently said, there is no reason to be afraid of the APA. The Federal Circuit and a whole lot of other intellectual property folks have kicked and screamed and fought every step of the way about the applicability of the APA in these areas. My wife clerked on the Federal Circuit in 92, 93. I could tell you stories. I watched oral arguments. But no, she's 100% right that from an administrative law perspective, the APA absolutely governs all of these matters, and that has implications for the way the PTO does things and the way the courts respond to it.
So just to have a kumbaya moment with Professor Lawson, if the courts had decided Microsoft versus I4I in the right way, I don't think the need for the PTAB as a policy matter would be nearly as acute.
That's where they got the standard for reviewing the validity of patents wrong.
didn't matter. Yeah, that's where they decided the APA didn't matter, and they
Right,
cite.
right,
That's where they
yeah.
ignored Professor Duffy's brief.
Ignoring Professor Duffy is never a good idea. Is that something we can agree on here? Yes. I think something that was just said inspired a hand down here, front and center. Can we have a microphone?
So I I hope someone will correct me if I'm wrong on this, but my understanding of the Microsoft versus I4I decision is that they were merely putting into effect the statutory requirement that granted patents be accorded a presumption of validity. They did that through a heightened standard for, I guess, overturning the patent right of clear and convincing evidence being higher than a mere, 51% kind of analysis. Is that right? Was that the right case?
Yes, that is the case.
So there's statutory language that says they're to be presumed valid. I don't know how else to do that.
So I have a 75-page law review article from 2007 about this. Presumed valid is boilerplate in so many different organic statutes. So we have a long, boring set of citations about different situations where the Supreme Court has said administrative action is always presumptively valid in cases where they've applied the APA.
Just a follow-up to that.
Wait, if we're going to have a follow-up, you need the microphone back.
Okay, yeah, sorry. I grant that there's such a variety of contexts where different rights are granted through administrative procedures. Absolutely no problem there. You said that the organic statutes also say that those other rights, whatever they may be, are to be accorded a presumption of validity. Is that right?
Yes, so the organic statutes do have language in other agency contexts saying, presumption of validity or presumed valid. Yeah.
All righty, thank you. Next, some exercise for our microphonists. I think we have a question in the third row from the back.
Thank you. In the whole Article 3 versus PTAB or other agencies, where do Article 1 courts fit in? There are two that come to mind that do consider patent validity, Court of Federal Claims and the ITC. Are those valid?
Did you hear that, Gary?
Constitutional?
Yeah, I heard enough of it so that I think I get the gist of the question. Where do Article 1 courts fit into all of this?
Yes.
Yeah, and the answer is it depends on the Article 1 courts. There are some of them that can be justified based on greater includes lesser or waiver ideas. Much of the original, the Court of Claims, Claims Court, Court of Federal Claims, whatever label it has this coming Thursday, if one believes in federal sovereign immunity, which is a whole separate question, then you can generate that particular court. Territorial courts, I have a big problem with. I have for a very long time. I've been writing about that for almost 30 years now. So I think those are dubious. Bankruptcy courts, we all know the ups and downs of that. You need to have an Article 3 actual real court entering the judgments. So it would require going through systematically institution by institution by institution. But the short version is, if the essence of what the body, the tribunal, is doing is depriving someone of life, liberty, or property, it has to be done by a real, honest-to-goodness judge. If what they're doing is simply handing out benefits, that they can do. Because then they're not courts, they're executive agents, and executive agents can hand out stuff if statutes say, go hand out stuff. So the now discredited right-privilege distinction is discredited only because the Constitution has been discredited. But if you're actually trying to figure out what the document says, life, liberty, property, those are rights. Other stuff, privileges. It's a right, you gotta have a court.
And I think because we're running out of time, we're going to give Professor Rye the last word. And then we'll take a 15-minute break, and you can continue to discuss in the lobby. Professor Rye.
I'll just follow up on what Professor Lawson said. So Professor Lawson applies, very, unabashedly 18th century law. If one were to apply 20th century law I think the ITC is a little bit different because its decisions don't have preclusive effect on Article 3 courts. So arguably, that's a little bit different from what the PTAB does.
And on that note, thank you all very much. Thanks to our panel.
Thank you.